Good morning, good afternoon, and good evening, everyone. Thank you for joining us in today's webinar, jointly organized by YSIAC and DIS40 on civil and common law perspectives on due process and arbitration. My name is Jennifer Lim, and I'm counsel at Sidley Austin's Singapore office and a member of the Young SIAC committee. On behalf of YSIAC, we are delighted to work with DIS40 co-chairs Johanna Bruskens and Alessandro Covi to organize today's webinar. This webinar addresses the ever important issue of due process concerns in international arbitration and how the specter of set-aside or non-recognition of an award affects case management and counsel strategy during arbitration proceedings. I am particularly excited because today we have a remarkable lineup of speakers who among them are admitted to practice in 7 jurisdictions in 4 continents. It would be interesting to see how similar or different these jurisdictions are in their approach to due process in international arbitration. For those of you who are not familiar with Young SIAC, YSIAC is the young practitioners arm of the Singapore International Arbitration Center. It aims to provide a forum for young professionals aged 40 years or under to exchange expertise, ideas, and experience in international arbitration. An example of that is this very webinar. Membership of YSIAC is free, and you may apply to join it on the SIAC website. Thank you. With that, I give the floor to Johanna.
Thank you very much, Jennifer. Also from my side and on behalf of the DIS40, a very warm welcome. My name is Johanna Bruskens, and I'm a senior associate at the Hamburg office of Hanefeld, a small boutique law firm specialized in international arbitration and litigation. I'm also one of the co-chairs of DIS40, the below 40 organization of the German Arbitration Institute. You can also become a member in our organization. It's also free of charge. And I also invite everyone to follow DIS40 on LinkedIn. We just set up an account so that you really stay up to date on all our future events. With me is also Alessandro Covi. He's another co-chair of the DIS40 and a senior associate at Herbert Smith Freehills in Frankfurt. Before I hand over to our moderator, Bronte, I would like to thank Young SIAC for handling the logistics of today's event. Thank you very much. And furthermore, one small housekeeping matter. We really invite everyone to post questions through the Q&A function. We will monitor your questions and our moderator will then post selected questions to our panelists. Now I would like to introduce our moderator to you. We are very happy that Bronte Hanna will moderate today's panel. She's a senior associate at the Munich office of CMS, where she specializes in international arbitration with a particular industry expertise in construction and post-M&A disputes, as well as in disputes arising out of joint ventures and distribution supply agreements. She's admitted to practice law in Australia and therefore the perfect addition to our multi-jurisdictional panel. I now hand over to Bronte.
Thank you so much for the introduction, Johanna, and thank you for having me. Welcome to all of our participants as well. Good evening in Singapore and happy lunchtime in Europe. So it's my absolute pleasure to be here today and be moderating this panel, and a big thank you to DIS40 and Young SIAC for organizing. We have a very highly esteemed panel today, and I'm very pleased to introduce them. I will start with Catrice. Catrice Geyer is a counsel at Herbert Smith Freehills in Düsseldorf. She's a German qualified lawyer who also holds a maîtrise en droit from the University of Paris, as well as a postgrad diploma in law, specializing in international business law and dispute resolution from Queen Mary UCL in London. Catrice is currently co-chair of the Below 40 chapter of the Swiss Arbitration Association and a member of the ICC Commission on Commercial Law and Practice, which has published on force majeure, hardship clauses, and Incoterms. Catrice's focus is on general commercial arbitrations as arbitrator and on technically sophisticated disputes as counsel, including high-end products, manufacturing, engineering, and construction. So welcome, Catrice. How are things in Düsseldorf today?
Very good, and thank you for the kind introduction, Hannah. It's beautiful weather.
That's nice to hear. It's also beautiful in Munich today. And now we're going to take a journey to Singapore, and I'd like to introduce Tang Pan, who is partner at YKVN in Singapore. Tang is dual qualified in Vietnam and California. He has a Bachelor of Law from Hanoi Law University and a Master of Law from the University of California, Berkeley. His practice focuses on Vietnamese transactional and arbitration matters. He has represented the government of Vietnam, major state-owned enterprises, foreign investors, and other Vietnamese companies on Vietnam-related matters, including investor-state disputes, oil and gas disputes, professional malpractice liabilities, shareholder disputes, and contentious corporate restructuring. So welcome, Tang. How is everything in Singapore today?
Very good today. Thank you for your kind introduction, Bronte.
Great. And our third panelist is Simon Elliott, who is a partner at Three Crowns LLP. He was previously based in Paris, but he's now based in Singapore. Originally from New Zealand, Simon is qualified in his home jurisdiction, as well as in England and Wales and France. His practice focuses exclusively on international disputes, and he has represented states, state entities, and private parties in a wide range of commercial and investment treaty proceedings under the major arbitral rules and in ad hoc proceedings, with a particular focus on large project disputes. I believe Simon is joining us from Paris today. So welcome, Simon. How are things in Paris?
Thanks, Bronte. Things in Paris are very good. I can see the Eiffel Tower from where I'm sitting right now, which is always a lovely view.
Yeah, that sounds terrible. Thanks for joining us today.
Thanks.
So before I start to pose tricky questions to our panel today, we thought it would be a good idea to start the webinar with a few words about today's topic, which is due process and who is afraid of due process. So due process is a fundamental principle that requires the fair and equal treatment of parties throughout the judicial process, which includes both in front of state courts or arbitral tribunals. Focusing on arbitration, and by way of example, the principle of due process is contemplated in Article 18 of the UNCITRAL Model Law on International Commercial Arbitration, which reads as follows. The parties shall be treated with equality, and each party shall be given a full opportunity of presenting its case. The concept of due process encompasses, in particular, the party's right to be heard, which is the aspect that we will focus on in this webinar. While this may not sound like something to be afraid of, it is of utmost importance for a tribunal to safeguard due process and the party's right to be heard throughout the proceedings, because a violation thereof can constitute grounds for setting aside an award or for refusing its recognition and enforcement. This is reflected, for example, in Articles 34 and 35 of the Model Law, as well as in Article 5 of the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. With that said, let's now turn to our panelists to gain some insights from their practice and explore in further detail the so-called specter of arbitral proceedings and how it manifests in various jurisdictions. Turning to you first, Simon, could you just tell us how the party's right to be heard is protected in arbitral proceedings?
Yeah, sure. I'm going to talk about how the right to be protected or the right to be heard is protected under English legislation. But before I do that, I thought I'd just touch briefly on kind of the hierarchy of norms that we typically see in municipal arbitration legislation. What you usually see consistent with the consensual basis for arbitration is that party agreements reign supreme. subject, of course, to any mandatory provisions of municipal law. After that, tribunals are given a discretion, and it's usually pretty wide, to conduct the proceedings as they determine appropriate, subject only to the parties' due process rights. And then with increasing frequency, we're also seeing an obligation on arbitrators to ensure cost and time efficiency. And so when we return to the English position, that's effectively precisely what we see. So under Section 33 of the English Arbitration Act, we find the obligation to give parties a reasonable opportunity to put their case and deal with that of their opponents, and note that it's a reasonable opportunity, not a full opportunity. We also find an obligation on the tribunal and the parties to adopt procedures suitable to the particular case, avoiding unnecessary delay or expense. Then in the neighbouring provisions, Section 34, we find the discretion of the tribunal to conduct the proceedings enshrined. The tribunal has the discretion to decide all procedural and evidential matters, subject to the right of the parties to decide any matter. And we find in Section 34 a whole laundry list of procedural matters that are within that discretion of the tribunal. So things like the location and timing of hearings, the existence and form of any written pleadings, when they should be filed, the extent to which they should be amended, and also, the extent to which the tribunal should adopt an inquisitorial approach to the ascertainment of facts and law. So that's the position under the English Arbitration Act. We see a broadly similar position under the LCIA rules in Article 14.
Thank you. I think the English approach sounds relatively straightforward. Maybe I can turn to you now, Catrice. What is the approach in Continental Europe?
Yeah, thank you, Bronte. I will simply very shortly cover Germany, Switzerland and France, but of course with a focus a little bit more on Germany. Well, in Germany, we have also, of course, the German arbitration law. We are a model law country in contrast to England, although the question really arises whether it makes such a big difference. And the most important section that is relevant for our webinar here today is also our section 1042. And this is based on Article 18 of the model law. And it basically says what you have already referred to, Bronte. The parties shall be treated with equality. And then if you translate it word per word, the English wording would be each party shall be given the right to be heard. But often you hear also the wording that Bronte has referred to, each party shall be given the full opportunity of presenting his case. So this is basically what happens under German law. What are the limitations? The most important one is really that if you are aware that your right to be heard has been violated as an aggrieved party, you need to object to this without undue delay. Because if you don't do that, then in post-award proceedings, you can't raise anymore this objection. And then there's also a second limitation, which is also provided for in German arbitration law, and that is, to put it in a nutshell, the procedural timetable. So if there are deadlines, for example, for the statement of claim and the statement of defense, in principle, these should be complied with. We will see later on with a couple of example cases whether this always holds true, but this is the basic principle. Turning now quickly to Switzerland. Switzerland here as well, it's not a model law country, but you find the Swiss arbitration law in chapter 12 of the PILA. This is the so-called Private International Law Act. And here again, to cite the wording of Article 182, paragraph 3, it reads, and I quote, "The arbitral tribunal shall ensure equal treatment of the parties and their right to be heard in proceedings." Okay, so this is the wording which you find in Switzerland. And what is important to note, and Simon has already touched upon that, the right to be heard is mandatory in nature, and it also forms part of procedural public policy, not only in Germany, but also in Switzerland and also in France. And here maybe touching shortly upon France, there you find in Article 1510 for international arbitration proceedings, the relevant section. And here I quote again, It says the tribunal shall ensure that the parties are treated equally and shall uphold the principle of due process. So what are the three, let's say, key takeaways if we listen really and see the wording in the different arbitration laws? The first is the right to be heard is mandatory. The second is, if you are aware that it has been violated, in principle, you have to object it in due course. Otherwise, you will lose your right to do this later on in post-award proceedings. And the third takeaway is, and this has still to be analyzed, that the wordings of the respective arbitration laws differ slightly, but the question is really whether this different wording results in substantial different results when you consider the same set of facts.
Thank you, Catrice. I think that last point is particularly relevant for the international arbitration context, where we do deal with various jurisdictions, but we all want our same right to be heard. Moving to Tang now, what's the approach in Vietnam?
Thank you, Bronte. So the approach in Vietnam is similar, I think, to other model law countries, even though the concept of due process or natural justice or procedural fairness is not, directly provided anywhere under Vietnamese law. But we do have, manifestation of those concepts, those principles in various provisions of the arbitration law, the Civil Procedure Code, and the Civil Code of Vietnam. Now, in particular, in the context of setting aside an arbitration award, the arbitration law of Vietnam doesn't provide for one of the bases in the model law, which is the parties cannot present its case. But the arbitration law of Vietnam provides for the case where the tribunal violate the procedures as agreed by the party or the procedure required by law, and that is a basis to set aside an award. And courts in Vietnam has been using that basis to set aside the award where the tribunal, failed to afford the party the equal treatment or the equal right to present its case, which is a principle, the general principle. Equal treatment is general principle under the arbitration law. In addition to that ground, the public policy is also a ground to set aside arbitration award in Vietnam, and courts also have been seen to rely on public policies to set aside arbitration award, which violate the equal treatment of the parties. Now, moving on to recognition and enforcement of foreign arbitration awards in Vietnam, you will see much more similar wording because the Civil Procedure Code of Vietnam codified Article 5 of the New York Convention, because Vietnam is a party to the convention, except for only one small variation, where the New York Convention refers to the right of the party to present its case. The Vietnamese Procedure Code provides for the right of the party to exercise litigation right. Now, there are, cases where the court have been using that, have been interpreting that litigation right very broadly, which include not only the notice, the requirement to send proper notice, but also like procedural fairness or equal treatment in the procedure of the arbitration. So that's basically a very brief overview of the position in Vietnam.
Thank you. Just to ask a follow-up question with that, the result of this deviation in the wording, is it narrower? I know you said they can interpret it broadly, but is it generally, would you say it limits it, or it's broader, or it's more or less the same, even though the wording is a deviation?
It is broader. It is broader than the original meaning of the wording. And take for an example where an arbitration award had been refused recognition, and the court using that provision, the court basically saying that even though you follow the expedited procedure, which is allowed under an arbitration rule of one institution, but you didn't give notice to the parties of the list of the arbitration. You didn't get the parties' agreement on such appointment. Therefore, you fail to comply with the notice requirement, and therefore that is one of the situations where the litigation right of the parties have been violated, and therefore we refuse to recognize the award. So there are other cases where we can see that the court basically imbued a very broad interpretation of that provision.
Thank you. Yeah, that's very interesting. So we've heard a bit about how due process is enshrined in your various jurisdictions. Now turning back to you, Simon, perhaps you can explain what does this mean in practice? What does due process entail?
Sure, thanks, Bronte. So I'm just going to talk about this at kind of its most general level. And I was casting about trying to find a pithy statement of the position on that in jurisprudence. And I won't deny that I was pleased to find that the New Zealand High Court had actually had a go at this in a 1992 decision. And so what they said was that in general terms, the right to be heard means that each party must be given a reasonable opportunity to understand, test, and rebut its opponent's case. There has to be a hearing of which reasonable notice is given, and parties and their advisors have to have a reasonable opportunity to be present throughout that hearing. In addition, arbitrators are precluded from taking into account evidence that's extraneous to the hearing without giving parties notice that they're going to do so and an opportunity to respond to that evidence. And this principle actually extends not just to evidence that the arbitrator might kind of find elsewhere than in the record, but also to their own ideas and opinions, if those ideas and opinions weren't reasonably foreseeable as potential corollaries of opinions and ideas that were traversed during the hearing. So these are the kind of broad principles that they set out in that decision. And obviously hearing here was being viewed through perhaps more of a common law lens, and in the New Zealand context, which typically requires an oral hearing. Certain common law contexts, and much more frequently in civilian jurisdictions, as many will know, you might only have a right to a written hearing. But boiled down to its essence, the right to a hearing, I think, means an appropriate procedural opportunity to put your case, to know and respond to the case against you. And that includes not just the case that's put by your adversary, but also any adverse evidence or arguments that the arbitrator might be minded to take into account in finding against you. And so in very general terms, this will usually mean that you get an opportunity to reply to the opposing side's submissions and the evidence that they file. To the extent that it's not contained in the submissions and evidence filed by your adversary, you get to have visibility and an opportunity to comment on any other information, materials, or arguments that the tribunal might take into account in reaching its decision. And there's one kind of general example or question here that I wanted to touch on very briefly, and it relates to tribunal appointed experts. This can give rise to questions of due process and the right to be heard. I was involved in a very large project dispute a few years ago in the nuclear sector, and the tribunal in that case appointed its own delay expert because the delay issues on that case were particularly complex. And a question came after a hearing on delay issues: can we, the tribunal, have access to the tribunal appointed expert when we're deliberating, so to ask them questions? And so we thought about that, and we thought, well, that's actually potentially quite problematic for us, because the delay expert appointed by the tribunal could be giving them opinions that we haven't seen, that we haven't had access to, and we haven't had a chance to respond to. And so in that case, we decided that we would diplomatically and politely decline the tribunal's request. And so we ended up agreeing a process by which we could have visibility on those exchanges, or at least the questions that the tribunal wanted to ask.
That's interesting, Simon. And just out of curiosity, was the other party on the same page as you when it came to the tribunal appointed expert, or would they have been fine with the process suggested by the tribunal?
Yeah, they were also uneasy with it, so it was a common position of the parties happily.
Good, thank you. Catrice, did you want to share the approach in Germany?
And yes, happy to, and maybe also in order to avoid some repetitions, I mean, the general framework and the general principles that Simon set out to a certain extent, of course, also apply in Germany. So you have to have the opportunity to present your case. You have to have sufficient notice of all the opponent's pleadings. And of course, also to have the opportunity to reply, for example, to new or additional submissions made by the opponent. And yes, you also have the opportunity and should have it to present at oral hearings, although I was involved in one case where the parties had agreed in the procedural timetable only in one round of submissions and had left it open whether or not a hearing, an evidentiary hearing should take place. And then the tribunal decided no and issued an award, and this award was actually upheld by the Swiss Supreme Court because they said that's the agreement of the parties. They had basically forgone their right. They didn't want a hearing. And if you don't want it, you have to live with the consequences thereof. And it was an agreement of the parties. So you always have to be a little bit careful what you agree at the outset of proceedings. It might, well, come to bite you. But I would like to touch upon two important issues that I think inform quite nicely how usually tribunals with a place of arbitration in Germany can act, and also how they can basically structure the procedure. And I think one issue was already touched upon by Simon, and we call it sometimes the so-called surprise and surprising decisions doctrine. What it is really about. Sometimes the tribunal, and very often actually, it intends to base its decision on legal considerations. And the question then is whether these legal considerations could have been anticipated by a prudent and reasonable counsel or a party. And to put it in a nutshell, if it is anticipated that a prudent and reasonable party could not have anticipated it, the tribunal should share this legal consideration and obviously give the parties the right to comment upon that, so that the right to be heard is actually complied with. The question, however, is now, how far does this duty of the tribunal reach? And I would like to share two examples that also show a little bit development over the years. And I was involved in the first one, which is already more than 10 years ago. And what happened there, the question was a legal question whether both claimants in the proceedings have standing to sue. And it boiled down to the question whether the assignment of claims arising out of the contract that was subject to the arbitration was valid. And why was this a question? The parties to this contract had contractually excluded the right to assign the claims. That happens. However, under German law, if it is a B2B relationship, you cannot so easily exclude this right to assign claims. What happened was that the tribunal handed down a partial award on this specific legal question and said, well, yes, you have contractually excluded this possibility of assigning the claims, but this is not valid under German law. And the other party said, well, that is a surprise decision that violates our right to be heard. And it was decided, no, it wasn't. This is the governing law. And as a counsel, you should be aware, obviously, of the law that governs the dispute. So this is not, let's say, a surprise decision. And this jurisprudence can a little bit be extended and to maybe touch upon a more recent decision of the last year. There it was not about the governing law itself, but basically about case law of the German Supreme Court. And it related to very specific questions, how you calculate damages. And here as well, the tribunal had handed down its partial award, basing its damage calculation on this specific decision of the German Supreme Court. And the respondent then said also, that was a surprising decision. We should have been aware that you want to base your legal considerations on this case law. And here again, the competent German court said, no, this should have been known by a reasonable and well-informed counsel. So far about surprising decisions. The second issue I would like to touch upon is the question of relevance. And it basically boils down to the following question. Does a tribunal have, for example, to hear all the witnesses that have been offered as evidence, or all the experts, for example? Or is the tribunal entitled to say, yes, I will hear this witness, but only on these two specific issues, because only those two specific issues are really relevant to the outcome of the case? And here you will find also, I wouldn't say long-standing case law, but a lot of case law of regional higher courts that confirm that a tribunal can do this. And to be more precise, a court in post-award proceedings cannot substitute its own assessment of the relevance to the one that has been done by the tribunal. What does that mean? In essence, we're talking about the prohibition of the révision form, because cases before state courts in post-award proceedings are not re-litigated. And the question of whether, for example, a specific contested fact is relevant to the outcome of the case also is about the application of the governing law. So therefore, state courts say, we are not going to reassess whether this decision of a tribunal to dismiss, for example, a witness for lack of relevance is okay or not. So I think this also shows quite nicely how tribunals can act without being too concerned about due process. However, some short notice here. Of course, tribunals can decide upon that, but often tribunals are, of course, also a little bit reluctant to do that. And why is that? First of all, they want to have the parties their right or their day in court, as we always say. But the second most important issue might be that by hearing even a witness on non-relevant issues, you somehow enforce a little bit better the acceptance of the award, even of and for the party that loses at the end of the day, because their witnesses have been heard. So sometimes tribunals nonetheless will hear a witness, will review all the documentary evidence, although it might not be relevant at all, in order, let's say, to avoid at the end of the day that the award debtor really tries to have the award set aside. So this is in a nutshell with two very specific highlights of what happens in Germany.
Thank you for sharing. It sounds like the German courts take quite a strict approach with quite a high threshold, and I think it's necessary in particular with regard to surprise decisions. Otherwise, every disappointing decision would also be a surprise decision in the view of counsel, I imagine. So moving now to Tang, did you have anything you want to add from the Vietnamese or from Singapore?
No, I echo what Simon and Katrick have been saying about the how due process will be reflected in the practice of arbitration, and we see that the principle, the guarantee of due process principle is applied in various stages of an arbitration process. And it is reflected in many of the institutional, the rules of many arbitration institutions. Here in Vietnam, the YSIAC and Singapore, the SIAC. For example, we see that the practice of procedural conference and procedural orders, where the tribunal will set up the timetable, the process for conducting an arbitration, the route of submission, filing of evidence, and how the parties will present the case at the hearing. Those are very important tools for the tribunal to ensure, to balance between the efficiency of the arbitration and due process compliance, right? Another point I would like to mention here is oral hearing. Like in almost every arbitration, oral hearings are almost always are required. And without the parties' agreement, and if the tribunal failure to hear oral evidence without the parties' agreement is a basis to set aside or refuse recognition of the award. Now, in the oral hearing, it is important for the tribunal to kind of allocate the time for each party carefully to ensure that each party have equal opportunity, equal time to present the case, to cross-examine the other side's witness statement. So those are the examples of how due process will be implemented and complied with in a general arbitration process.
Thank you, Tang. So, considering how significant the party's right to be heard is, which you've all made very clear, my question is if and when a party can waive its right to be heard. Simon, what's your experience in this regard?
So in the context of objections, in both England and France, yes, a party can be deemed to have waived their objections. And the basic principle is if you don't do it promptly, it will be considered to have been waived. So we can see that under Section 73 of the English Arbitration Act. You have an obligation under that provision to make your objections forthwith. And if you don't do that and continue to take part in the proceedings, then you risk having your objection treated as having been waived, with the possible exception that if you didn't know or couldn't have reasonably known, then you may get a pass. It's the same in France under Article 1466 of the French Civil Procedure Code. And there's one case actually where a party was quite ambitious in trying to raise an objection after the conclusion of a hearing. That attempt fell flat for two reasons. One, at the conclusion of the hearing, the party had thanked the tribunal for the quote unquote very fair conduct and efficient conduct of the hearing. And then in their post-hearing brief, they hadn't raised any concerns. And so later on, when they pitched up and tried to argue that the hearing had been conducted in a way that impinged upon their right to be heard, they didn't get a sympathetic audience from the Paris Court of Appeal.
I'm guessing that more weight was attributed to the fact they didn't raise any objections in their post-hearing brief than the thank you at the end of the hearing.
I didn't detect a particular weighting from the decision, but yeah, I think the lack of any actual waiver was probably the lack of any actual objection at the time was probably given more weight, I would think, rather than the pleasantries exchanged at the end of the hearing.
Great, thank you. Tang, I have a question for you about in this context as well. So if the parties agreed to arbitral rules, which they're free to do, so rules of procedure to apply in their arbitration, which made their right to be heard narrower than it is under Vietnamese law, does that constitute a waiver? Is that permissible in Vietnam?
The general principle is the parties are free to agree on how they want their dispute to be resolved and in what procedures, right? So I think that the principle of respecting the parties' agreement is also the basis to the rule that Simon just mentioned earlier, which is if you don't object, that means you agree, and that can be deemed as a new agreement, right? So that also means that the parties can agree on using the rules of arbitration centers around the world or in Vietnam. Now, the case you just mentioned is, let's say, if the arbitration rules, or let's say if the IBA rules on taking of evidence provide for some procedures that is narrower than Vietnamese law, then will start enforced in Vietnam, right? The general view in Vietnam is, yes, you have to respect the agreement of the parties. That means if the parties have agreed on some procedures, that means that has to be respected, and that is not a violation of due process. However, there have been cases, different courts in Vietnam, and the courts still take the more narrow view that, even if you agree on an arbitration rule, but if the principle in that arbitration rule do not comply with Vietnamese requirement of the procedure, the court may still refuse recognition of such an award. So courts are split on whether or not it is a waiver and whether or not such a waiver will be enforceable in Vietnam.
Thank you. That's an interesting position then taken by the courts, or half of them, in Vietnam. Moving over to you, Catrice, there's a situation I want to address that Simon also briefly raised. Unfortunately, it's not uncommon for one party to boycott the arbitral proceedings insofar as they refuse to participate. How does this work in practice, given both parties' right to be heard?
Yeah, a very valid question indeed. In practice, I mean, what does it mean? From a tribunal side, you have, of course, to ensure nonetheless the enforceability of an award. If you basically issue, let's say, an award ordering the respondent who has not participated in the proceedings, for example, to pay damages. At the end of the day, it comes down to the following. The right to be heard does mean you have to have the opportunity to be heard. And as long as you have been given this opportunity, but if you don't use it, your right to be heard has not been violated. The question is, however, how do you ensure that this opportunity is really being granted? And here it becomes a little tricky in practice. I had, for example, one of my first arbitrator cases where the respondent was not responsive. And so at the end of the day, and it was an ad hoc proceedings, so you did not have the support of the institutions, which can be quite helpful in that regard. So we really have to make sure with all kinds of notifications that you know that the respondent has really received the request for arbitration, the draft procedure order, the draft procedure timetable, and basically by postal service that someone really has received it. And I got the confirmation, and I did it basically for all the procedure orders twice. And there were 3 respondents that were not responsive. So it was a little bit cost intensive, but this ensured at the end of the day, they had been given the opportunity to comment upon everything, but they did not do so. And I even extended once or twice the deadlines because I did not hear back from them to respond, for example, to the statement of claim. And I said, okay, additional 2-3 weeks. The statement of claim was not that long. And this is how then you can ensure in principle that the award will be enforceable. But let's say it's not without problems. In certain jurisdictions, you will not have a possibility to serve upon the respondent if it, for example, is their jurisdiction. We have that in Syria or in other countries. Well, you can't serve the request for arbitration and even wire embassy on help, and via the ICC it was not possible. Or funny enough, what can happen after 2 years, we had this in another case now, then suddenly the other party said, I received emails the last 2 years for the appointment of the arbitrator, pleadings, should I have responded to that? And then we of course said, great, okay, now you have confirmed that you have received anything. Why you have not responded to your emails, we can't say. But this at least will ensure that we can enforce the award against you, which was shortly before being issued. So this is basically, how to, let's say, ensure that although a respondent does not want to participate, to ensure a little bit the enforceability of the award.
That certainly sounds like a position where an arbitral tribunal wants to be very, very cautious.
Yeah.
So moving on to a different situation for the tribunal, my question is for you, Tang, to start with. Can a tribunal refuse an offer of evidence from one of the parties? Do they have to accept absolutely everything, or is there a point in time where they can say, no, thank you?
Yes, the answer is the parties have the right to submit relevant evidence, right? So even though the tribunal do not have to address every evidence in the award, but they have to respect the parties' right to submit the evidence. However, there are situations where the tribunal just can say, that's it, that's the cutoff time. From this point on, no further evidence submitted. In Vietnam, we have the concept of the final hearing. So after the final hearing, no further evidence or submission can be submitted by the parties. And if the tribunal accept evidence after that point in time, court have been taken that as a basis to set aside the award. So that is something that tribunal should keep in mind in arbitration in Vietnam.
Thank you. Catrice, did you have anything to add on this point?
Well, not specifically, but we had also a case, it's a recent case that was also decided by a state court then in post-war proceedings. And here what had happened was that the parties were in dispute about the content of the agreement of how to calculate the purchase price. And there was a procedure timetable. Both parties could really submit full-fledged submissions with all the supporting evidence. And the parties had explicitly agreed to have only one evidentiary hearing. All the witnesses were examined, also on this particular disputed topic. And what happened then? Well, the tribunal directed the parties to submit post-hearing briefs and explicitly stated to comment just on the results of the taking of evidence that had taken place during the evidentiary hearing. And then suddenly the respondent thought, the content of this agreement of how to calculate the purchase price is still contested. We submit a witness statement. And then, of course, the tribunal had to decide about allowing or not allowing this belated evidence. And as you can imagine, sometimes it also goes the other way. In this case, the tribunal said, no, I'm not going to allow it. It is belated. There's a procedure timetable. You agreed upon it. I don't want to reopen basically the hearing and the whole procedure. And the state court then upheld this decision and said, well, yes, a tribunal has the discretion to decide on the so-called admissibility of evidence that is provided for in section 1042 paragraph 4, which is modeled on the basis of the model law. And it basically also informs what a tribunal can do, because often the timetables are subject to major discussions between the parties. Sometimes they can agree on the deadline, sometimes not, and then the tribunal has to give directions. And therefore, if all parties had the full opportunity to present their case before the evidentiary hearing and the value of the evidence could be tested, then no new evidence should be allowed. But of course, there might be exceptions, and we come later to that.
Thank you. And I was going to say while you're off mute, but back on mute again. I wanted to move on now. I see that we don't have a whole lot of time left, and we still have so much we want to share with our audience today. But I wanted to move on to the topic of due process paranoia. So perhaps, Catrice, you could just explain briefly what this is.
Yeah, to put it in a nutshell, I think everyone here in the audience has more or less heard about this notion. And to put it shortly, I would like to cite the survey of the Queen Mary University of 2015, and quote unquote, a growing concern in international arbitration is a perceived reluctance by tribunals to act decisively in certain situations for fear of the award being challenged on the basis of a party not having had the chance to present its case fully. And this is what basically one of the possible definitions of due process paranoia is about. And to put it, let's say, a little bit more in context, it's about two conflicting set of duties. The one is, for example, set out in Article 22 of the ICC rules. You have to act as an arbitrator efficiently and in a timely manner. And if you don't do so, you can even be, let's say, financially sanctioned by the institutions because they reduce your fees. On the other hand, and that is the second set of duties you have to act fairly and impartially and have to ensure the enforceability of the award. And let's say the second set of duties, to act fairly and impartially, may push arbitrators to be overcautious Whereas this first set of circumstances, to be efficient and act in a timely manner, be, let's say, a bit undercautious. Let's put it like this.
Thank you. And turning to you, Simon, can you give us some practical examples of how due process paranoia manifests?
Sure. And I'll try and do this very briefly given time constraints. So, I mean, you see this in a number of ways in arbitral proceedings. You see the grant of repeated extensions of time. You see tribunals accepting multiple amendments to written submissions, agreeing to the late submission of defenses and claims or new evidence, agreeing to last-minute requests to reschedule oral hearings. And I just wanted to share one example of this from my practice. It was a case a few years ago in the healthcare sector. The hearing was happening in Ontario, Toronto. None of the parties or the counsel or the tribunal were from Ontario, so we all had to travel kind of from different places in the world to have this hearing. For weeks prior to the hearing, it was agreed that we would have openings on the first day. It was a week-long hearing. Openings on Monday, witness examination Tuesday, Wednesday, Thursday, closings on Friday. So we get to Ontario on the first day. Counsel for the other side announces that his second chair won't be present on Friday because of a conflicting engagement, but nothing else is made of it. And then we go through the entire week. We get to Thursday evening, we're feverishly preparing our closings for the next day, and we get word that the other side has announced that they will not be there. They were not turning up because allegedly lead counsel was not in a position to close the case without second chair, even though he'd known and announced previously that second chair would not be there. And we could see that this put the sole arbitrator in that case in a very difficult position. He didn't want to agree to postpone the oral closings because we'd all traveled so far and none of us were from Ontario, Toronto. So the decision to postpone carried with it significant financial consequences. He ended up agreeing to postpone the closings, but required then that the closings be held in Paris, which is where claimant and claimant's counsel were based, and that the respondent bore all of the costs of the postponement. So in the end, we ended up doing the closings a couple of weeks later, and in the end, it wasn't a huge prejudice for us, but we could see actually the quite difficult position that this last-minute request put the tribunal in.
Definitely a difficult position, and probably well handled by the sole arbitrator at the time under a lot of pressure. I just want to turn to you, Tang, now and ask you, we've heard about how important due process is. So my question to you is quite bluntly, why is due process paranoia a problem?
It is the problem because it's the job of the tribunal to maintain efficiency and due process and the balance in between. Now, if the tribunal is so prone to accepting the abuse or the multiple requests by either party, it will cause inefficiency in the arbitration, and follow that will be delays and costs of arbitration. Now, and the second reason I will quote Professor Lucy Reed, which concluded that one of the consequences of the paranoia is the tribunal can be consciously or unconsciously biased toward a party, either because the tribunal accept so many requests, so they tend to accept some more, or either they grow frustrated about that party in particular. Now that is quite dangerous for the tribunal because from overly concerned about ensuring the due process, the tribunal will appear to be like granting too many requests of one party compared to the other, and that is appearance of bias. So sometimes we cannot tell if the tribunal is consciously biased or whether or not they are just accommodating requests from one party. So those are I think the key reason why the due process paranoia are particularly bad for arbitration.
Thank you, Cheng. Thank you very much. So I think it's time now for us to involve our audience. I hope that they're willing to participate with us. So each of the panelists has prepared a so-called war story. So they're going to describe a case out of their own experience, their own practice. And then we're going to use the poll function to see whether the audience believes that the award could be set aside on the basis of right to be heard, considering everything that we've heard so far. So we're going to start with you, Tang. Would you like to share your war story with us briefly?
Yeah. So this is the case in VIAC in Vietnam. The dispute is between a construction consortium and a Vietnamese employer. When the construction consortium completed 25% of the work, they decided to terminate the contract, and demanded the employer to pay for the work that has been done. And then, of course, the employer refused, and the contractor sued the employer in arbitration. And the seat of the arbitration was in Hanoi. Now, at the beginning of the arbitration, the tribunal decided to issue an interim relief, requesting the defendant to put a deposit of 10% of the amount claimed by the claimant in a joint account in the name of the claimant and the defendant. And the defendant objected to that interim relief decision and sued the tribunal and two of the arbitrators personally in a Hanoi court. Because of that lawsuit in the Hanoi court, the tribunal, concerned about their personal safety, decided, without consulting the parties, to move the hearing venue of the case from Hanoi to Singapore. Now, the defendant again objected to that decision, citing, the tribunal cannot do that without the agreement of the parties. The parties have agreed on Hanoi being the venue. You cannot change without our agreement. Then the tribunal doesn't concede. And once again, later on, they delayed the hearing date and also changed it another time from Singapore to Japan. And once more, the defendant objected to that decision. And the hearing went on without the participation of the defendant, and the award was issued in favor of the claimant. And then the defendant petitioned the Hanoi court to set aside the award. Then the question would be?
Exactly. Could we have the first poll question up, please, Emmeline? Thank you. So we're going to ask the audience now to vote. Yes or no, you have a 50% chance of being right. Can the award be set aside on the basis of the right to be heard? I'm going to allow 30 or so seconds for everyone to answer. It will be particularly interesting for those of us who have no experience in Vietnam, which includes myself, or I'm also going to answer. Okay. All right, can we see the answers? Here we go. So 79% of people said yes, the award can be set aside. There is a breach of the right to be heard. And 21% said no. So how did the audience do? Tang, can you reveal?
The majority of the audience is right. It was a case that was decided by the Hanoi court in 2019, and the court decided to set aside the award for the reason that the defendant couldn't, the decision by the tribunal to move the venue of the hearing to Singapore and again to Japan affected the ability of the defendant to participate in the hearing, and therefore affected its right to present its case. There is another detail in the court ruling, which is the tribunal didn't really take into account the evidence submitted by the defendant in the award for reason that the defendant didn't participate in the hearing. The tribunal relied on a rule of the IBA rule on taking evidence that says if you do not participate, if you do not provide evidence, we will exclude your evidence, or we could draw adverse inference on the evidence that you submitted. The court says you cannot do that. Even if the defendant didn't participate, you still have to consider the evidence submitted by that party up to that point. So for those reasons, set aside the award.
It sounds like a fair decision, if you ask me. Moving on now to Catrice, I think you've prepared a war story about quite a significant case in Germany. Would you like to set out the details for us before we ask the audience?
Yeah, happy to. I tried to keep it a bit shorter. It was basically a dispute arising out of an SPA dispute, and the buyer had basically refused to pay the purchase price, arguing that the seller had breached the so-called ordinary course of business provision that you often find in SPAs, and that therefore the purchase price had increased. And then the buyer had said, no, I don't pay. As a consequence thereof, the seller filed a request against the buyer for damages. What happened then, the proceedings were bifurcated in a liability and a quantum phase. And in the liability phase, the arbitral tribunal had handed down an award, holding the respondent liable. And then the question, of course, arose how the procedure will be followed up in the quantum phase. And as it happens quite often, a conference call was scheduled, a procedure call. And here comes, let's say, the decisive part. At the beginning of this call, the chairman advised the parties that the taking of evidence for the calculation of damages will strictly follow the DIS arbitration rules, unless the parties agree otherwise. And then the tribunal also advised the parties, if they want to agree otherwise, that the tribunal is happy to document this agreement in a procedure order. So following this procedure conference call, a draft procedure order was circulated, and both parties commented upon that, made some amendments, and based on that, the tribunal issued this procedure order. And I will shortly cite the introduction of the procedure order. It was in German, so it is an English translation. Quote, unquote, furthermore, the arbitral tribunal documents the parties' agreement as to the content of written submissions. And further on, it stated that party-appointed experts have to attach to their expert report any documents that they have reviewed and taken into consideration. And what happens, of course, afterwards was that the seller has submitted an expert report, but the expert report did not contain all the documents that the expert obviously had attached and had reviewed prior to that. And the buyer then said, well, that can't be. Dear tribunal, please order the seller to produce the documents. The tribunal dismissed this request and said, well, I have a discretion here as regards document disclosure, and therefore the seller does not need to submit the documents. And what happened then? A final award was rendered, and in the final award, the buyer, based also on the considerations of the expert instructed by the seller, had to pay more than 200 million euros.
Okay. So that's quite a big price tag. And then we have the second question coming up. So audience, please, submit your votes. Do you think the award was set aside on the basis of the right to be heard? Yes or no? I'm going to enter my answer too. Catrice knows the answer, so no cheating. Very good. Okay, we'll give it a few more seconds for everyone to think about it. Here we go. 63% said yes and 37% said no. So still, we're all in favor of the right to be heard in this audience, slightly less than in Tang's case. Would you like to reveal, Catrice, what the result was?
Yeah, happy to. That is, let's say, it was a tricky question, and it was a misleading question, to be honest. And just for everyone's information, this decision of the Regional Higher Court in Frankfurt is sometimes also called the Frankfurt Trap. And it is called for that for some reason. Yes, the award was set aside, but the most important reason was not that the right to be heard was violated, but that the agreement of the parties had not been complied with by the arbitrator. And this is, so in a nutshell, yes, the award has been set aside. And basically what the tribunal said, well, the court said, sorry, if as a tribunal, you really ask the parties to agree on how the procedure shall be conducted and what kind of evidence shall be submitted and how the evidence shall be examined and tested. As a tribunal, you cannot simply unilaterally deviate from this agreement. And by having done so, well, the tribunal had caused its downfall and thereby, have the award set aside. Just as a notion, this decision was discussed very, very heatedly in 2012 during an event of the German Arbitration Institution. And there were, I don't know, 100 or 200 people in the room who were fighting whether this is the right decision or not. So I think the audience got it right either way. But it is important to note for a tribunal, you have to be careful if you do it like this. Sometimes it's maybe better to simply ask the parties to comment upon directions that you want to issue and then issue them as a unilateral decision and not make an agreement of the parties in order to be in the position to deviate from your unilateral decision of how to conduct the proceedings.
Thank you for sharing a very important lesson for arbitrators in that case, I think. So the last war story before we answer the questions of the audience is from Simon. Would you care to share the details of that case?
I will. So this was a case that arose in the construction context and involved the construction of a cross-country pipeline. There are a whole range of disputes, and two of them are relevant to this war story. The first point of dispute was that the other side had advanced counterclaims which hadn't passed through the mandatory pre-arbitration dispute resolution procedures. And so we objected to the admissibility of those counterclaims. The other side argued in favor of the admissibility of the counterclaims. The tribunal went on to admit the counterclaims and accept the counterclaims on a basis which hadn't been argued by either of the parties. So that's the first procedural defect that we complained about. The second procedural defect that we complained about was that one of the other points in dispute involved the return of the retention monies that had been held under the mechanism for that in the construction contract. We made a claim for the return of the retention monies at the earliest stage in the arbitration, so in the request for arbitration. At no point throughout the briefing cycle was a defense to that claim raised. There was just radio silence. When we got to the opening, in fact, we were crowing about the fact that this claim was effectively accepted because no defense had ever been raised. At the hearing, still no defense was raised. Then at the end of the hearing, when giving directions for the post-hearing briefs, the tribunal laid out a procedure whereby the first set of post-hearing briefs should be fully recapitulative, so should include every claim, counterclaim, every defense that you want to make, should be advanced. Reply post-hearing briefs were to be strictly limited to matters that could not have been reasonably anticipated when the first post-hearing brief was filed. So in our first post-hearing brief, we repeat our claim for retention monies and observe again that the claim has never been defended and so must be taken to be accepted. In the other side's first post-hearing brief, no defense at all to the retention monies claim still. Then in the reply post-hearing brief, so for the very first time in the proceedings and at a point where we have no opportunity to reply, the respondent advances arguments for the first time under the retention monies mechanism setting out why it should not have to give them back to us. In its award, the tribunal relied on those arguments and declined our retention monies counterclaim. So these are the procedural facts for the poll.
Yes, there we have the third question. So based on the facts set out by Simon, can this award be set aside on the basis of the right to be heard? A little bit to unpack there for the audience, so we'll give them 30 seconds. I'm a very generous arbitrator, as you can tell. Before we reveal, I also need to vote. Now, after Catrice's case, I'm like, is this a trick question? What happened? Great. So give them a few more seconds. Here we have it. Again, 70-30 split, with 70% in favor of setting the award aside. What happened, Simon?
The award was not set aside, which to this day I still feel scarred by the whole experience, actually. And I should say that this case was actually my very first case as a young arbitration lawyer. So for a while, my faith in arbitration was shaken. Effectively on the admissibility point. So the court, the Ontario court, showed what I think was an extreme level of deference to the tribunal and an extreme reluctance to intervene in any way with the finality of interfere in any way with the finality of the award. On the admissibility point, the position that the court effectively took was, look, this wasn't a jurisdictional issue. So the only question was when these claims are going to go before a tribunal. There's no suggestion that if these claims had passed through the pre-arbitral steps that the result would have been any different. And so I'm not going to interfere. On the retention monies claim, a similar level of circumspection was evident. Effectively, the court found that because we, in the course of advancing our positive claim, had made submissions on the provision which contained the retention monies mechanism, then we had addressed the provision that the tribunal relied upon, and so we could not complain that we hadn't had an opportunity to respond, or that the arguments had been taken us by surprise, effectively, that we'd some way been constrained in our opportunity to present our case, which I found to be slightly torturous and tortured, both torturous and tortured reasoning. So yeah, so there you go. It's one illustration, I think, of just how high the threshold can be in certain jurisdictions and how reluctant some national courts will be to interfere with the findings in an award.
Thank you. That's also what we like to hear, I think, as arbitration practitioners and future arbitrators. We just have a few minutes left to be precise, and we have exactly 2 questions from the audience. So 1 minute per question I will allocate generously. The first question we have here from Adita. She's asked, in key points from civil versus common law perspective, are there any differences on how due process in arbitration is treated in terms of national law, but especially by the courts? So I think you could probably write a PhD thesis on this question, but does anyone want to answer it just in a nutshell, or address it rather than answer it?
Happy to take a very brief stab, at least in terms of the way the courts in England and France seem to approach challenges based on a breach of the right to be heard. You actually see a relatively unified approach. So as in England, in France, it's a big no-no to do something which is going to take the parties by surprise. So to rely on evidence which wasn't available to the parties or to one of the parties, or to make findings on legal bases which weren't put to the parties and on which they didn't have an opportunity to make submissions. Conversely, when you come to a case management style of decision, there's a high level of deference shown to tribunals to exercise that discretion. And so there is think in the jurisprudence of both countries, evident a reluctance to second guess the discretion of a tribunal when it relates to a case management decision, like extending a deadline for a submission, or refusing to admit evidence after a procedural deadline.
Thank you, Simon, for answering that. And the other question is from Jose, who has asked about the extent of the right to be heard. Is given access to evidence and being able to respond enough? How about when the arbitrator did not allow the presentation of evidence on a certain issue? I don't know if Catrice or Tang, you want to answer about this situation?
I'm happy well, to take it upon. I think in a nutshell, we can basically refer to what we have stated a little bit, because yes, you have to be able to respond to the evidence of the opposing party. But as already stated, if the tribunal is, for example, really of the opinion that it's absolutely not relevant to hear this witness, then there's good reason for an arbitrator not to allow the presentation of evidence, or if it's, for example, absolutely belated and has been submitted only after an evidentiary hearing. So yes, I would hope that this in a nutshell answers this, but Jose, if you have any follow-up questions, just let us know. It really depends a little bit on the specifics of the case, of course.
Okay, I might ask one more question that's come in, if we don't mind, and Tang, maybe you can answer this one. Franz has asked what should be avoided with regard to the right to be heard so that an arbitral award is not set aside and is enforceable. Do you have maybe just a couple of takeaways there?
Yes, from the tribunal perspective, the most important thing to avoid is the appearance of unequal treatment to the parties, allocating different timing to the parties, refusing the evidence of one party but accepting the evidence of the other, allowing late or very late submission of evidence, or very late notice to the party, so that the other party do not have time to react to the new evidence or to the notice. Those are the very important points that should be avoided to ensure that the arbitration award will not be set aside.
Thank you very much. And one final question before we let everyone have their lunch or dinner. Kishore has asked, don't you think that stress on adherence to due process is good for the legitimacy of arbitration?
I'm happy to take this question as well. I think the arbitration is known for efficiency, not only because the thing that differentiates arbitration and court is efficiency and time for the parties. So over adherence to due process, it's good to ensure that the award will not be set aside, but then at the same time, the tribunal should also maintain the efficiency of the process. So what we have been pioneering in Vietnam is we are promoting the adoption of very detailed procedural orders that is curtailed or detailed for each of the case, complying with specific compliance reference to Vietnamese arbitration law or procedural law, and so that the parties will have a very predictable and transparent guideline and framework for the procedure to be conducted, and that will also avoid any due process challenges down the line if the arbitration award is issued. So yes, the answer is yes, but at the same time, you still have to ensure that the arbitration is effectively conducted.
Thank you very much, and thank you to all of our panelists. Unless you have something to add, I would wrap up now. We're a little bit over time, but I think we wanted to allow everyone the right to be heard. So I think we did this. Does anyone have anything to add before I close the session? Looks like 3 no's, and probably no from YSIAC and DIS40 as well. So just thank you very, very much for attending and for sharing the insights from your practice. I know as a young practitioner, they're just invaluable for us to hear and to take with us in our international arbitration toolkit. So yeah, enjoy the rest of your day, and thank you to the audience as well for your participation.
Thank you, everyone.
Thank you very much.
Yeah, everyone.
Bye.